Okay, so what is intellectual property rights? The property which has been created by what? Exercise of intellectual faculties. Nothing but the mental faculty. That is called as what? Intellectual properties. It is a result of person's intellectual activities. It involves certain element of what? Human skills. Correct, right? What are the types of intellectual property rights we have? Copyright, patent, trademarks, geographical indications, industrial designs, inventions, and undisclosed informations. Correct, right? Under copyright come under which act? Copyright Act. Which year? 1957. Trademark come under which act? Trademark Act 1999. And GI Protection and Registration Act 1999. Then Industrial Designs 2000. A patent 1970. Copyright is the oldest law. Copyright came into force from what date? 1957. Patent 1970. What is the difference between intellectual property and industrial property? Intellectual property is nothing but artistic work. Correct, right? That is called as what property? Intellectual property. And the properties which have an industrial applications like trademark, copyrights, patents, inventions, nothing but patents, geographical indications which are used for the commercial activities are called as what? Industrial properties. What properties? Industrial properties. Correct. Next one, nature of intellectual property. What is the nature of intellectual property? It is a intangible right over what property? Tangible property. Correct, right? It is a what right? Over what property? Tangible property. Good. Second one, right to sue. You can file a case against the one who does the infringement of copyrights or patent or the geographical indications. Third one, rights and duties. Correct, right? The one who has the copyright or a patent or any intellectual property, he has a right and the other person has a duty. Correct, right? One person right is the other person's duties. Correct now? And this right is both positive as well as negative. What is positive right? To claim that right to sell, assign, manufacture, distribute. What is the negative right? To prevent anyone who infringes the intellectual properties. Correct, right? Next one, coexistence of what right? Different right. In a single product, there can be a multiple rights. For example, in one product, there can be a copyright, trademark, then patent, trade secrets. Clear? Next one, exhaustion of what? Rights. What is the principle of exhaustion? Once the goods are sold, then the seller exhaust his patent right. The buyer can resell it. Correct? That is called as exhaustion of rights. Last one, dynamism is what? It keeps on changing. It keeps evolving with the societies. Clear? This is the nature of what? What right? Intellectual property rights. Clear? So we discussed what is intellectual property rights, what are types of intellectual property rights, under what laws they are governed, and the difference between what? Intellectual property and industrial property. Then we discussed what? Nature of intellectual property and why there is a need for intellectual property rights. Means why these rights should be protected. What is the first reason? Protection of what? Creativity and innovations. Very good. Second one, encourages the economic growth and investments. So with there are more patents. Last year, India registered more number of patents because there is a growth in the economy of the country. Correct, right? And even the designs, the number of designs registered in India is growing rapidly because of the startup India concepts. So with the increase in the number of intellectual property rights, what will happen? There will be an economic growth in the country. Correct, right? That is why this intellectual property right should be protected. What is the first reason? Protection of what? Creativity and innovation. Second one, encourages the economic growth and investments. Third one, legal rights to enforce the ownership. There is a legal mechanism by which a patent holder or a copyright holder can enforce his right. Third one, promote the fair competitions because it prevents the competitor from copying the what? Inventions or the trademarks. So it will promote the fair competitions amongst the competitors. And the last one is what? It supports the cultural and technological advancements. Then we discussed about the GATS. What is GATS? General Agreements on Trading Services. Correct, right? Under this we discussed All services are covered by what? GATS. It only deals with the services. For goods, we have a separate agreement. Correct, right? This GATS agreement is made by who? The WTO member countries. Correct, right? WTO. What is WTO? World Trade Organization. The members of the WTO made an agreement called as what? GATS, which is a multinational agreement. What agreement? Multinational binding agreement for trade in what? Services. Trade in services. So what is the first basic principle? It covers all the services. Second one, most favored nation treatment. What is most favored nation treatment? There should not be discrimination among the nations while allowing them to provide services in India. Correct, right? If you are giving an access to China, you should also give access to whom? Other countries. That is what called as most favored nations treatment. That is almost called as what? National treatment. What treatment? Most favored nation treatment applies to all services. What services? But this national treatment applies to only those services where commitment is given. What is given? Commitment is given by whom? Government. Commitment is given by whom? Government. Correct, right? What is national treatment? Treating the foreign players equal with what? Domestic player. That is what called as national treatment. What treatment? What is most favored nations treatment? Treating all the nations equal. Clear? Next one. Transparency in what? Regulations and inquiry points. Correct, right? So in case of regulation, there must be a transparency and the laws should not be arbitrary. They cannot be changed arbitrarily and the laws cannot be made arbitrarily. Correct, right? Next one. Regulations have to be what? Objective and reasonable. Nothing but it should not be arbitrary. Next one. International payments. What payments? Should normally be what? Unrestricted. This is the one more principle of what agreement? GATS. And member countries to this agreement should follow all these principles. Yes or no? Next one. Individual countries' commitments negotiated and what? Bound. And progressive liberalization. What liberalization? Progressive liberalizations. GATS doesn't recommend liberalization of the entire economy of a country. It recommends progressive liberalizations. Means it gives that scope for the developing nations to what? To amend the provisions of the GATS agreement according to the social condition of that country. Clear? So these are the principles of what agreement? GATS. What is the first principle? It is applicable to whom? All services. Second one, most favored nation treatment applicable for what services? All services. That national treatment is applicable only for those services where what is given? Commitment is given. And transparency in what? Regulations. And the second one is the regulations must be reasonable and objective. Reasonable and what? And the payment, what payment? International payment should be what? Normally unrestricted, subject to some conditions. What is the last provisions? Progressive liberalization. What liberalization? This is the one more important point in case of what agreement? GATS agreement. Next one, WIPO. What is WIPO? World Intellectual Property Organizations. This act as a controller of what? Intellectual property rights. So this will assist a person to register his intellectual property rights globally. It provides a system. It also provides a legal framework. It also provides assistance to what countries? Developing countries. What countries? Example, remember they have established a patent office in what? Bangladesh to support the intellectual property system in that country. Yes or no? That is the work of which organization? WIPO. That organization name? WIPO. Under WIPO, there is a contract called as what? PCT. What is PCT? Patent Cooperation Treaty, which helps a person to establish a priority date. What date? Priority date. What is priority date? Where you claim the invention earlier to whom? To the any other inventors. Correct, right? That is called as what date? Priority date. So if an application is made in a PCT country, what country? The member country, then the date will be considered as the date of what? Applications. Even if the application is made at a what date? Later date. But the application should be made within how many months? 12 months. How many months? So what is the ways in which WIPO works for the growth and application of what? Global intellectual property. There are 4 ways. How many ways? What is the first one? It provides a system. Who provides a system? Everybody who provides the system to obtain the what? Protection. For what? IPR. Nationally or internationally. That is why it is called as global organizations. What is WIPO? One, intellectual property organizations. Very good. Next one. It develops the what? International legal IP framework. What framework? What is IP? So it provides the legal framework or it provides the model law which can be adopted by what? The other countries. Clear? Third one is what? It builds a collaborative networks and technical platforms. What platforms? Including the free databases, tools for exchanging the what? Information. So they build that infrastructure for the exchange of what? Information. And what is the last one? It builds the capacity in the use of IP to support what development? Economic development by giving assistance to the various developing countries. This is the work of who? WIPO. What is WIPO? World Intellectual Property Organizations. Are we clear with this, everybody? Last one is what? TRIPS. What is TRIPS? Trade related aspects of intellectual property rights. What are the main areas covered by the TRIPS? How the general rules and fundamental ideas of global trading system apply to the what? International intellectual property. What are the minimum protection criteria? What criteria? Minimum protection criteria to be given by what countries? Member countries. What countries? Next one, what mechanism should members offer to defend those rights? The legal mechanisms. Third one, fourth one, specific interim framework for resolving what? Intellectual property disputes. Nothing but arbitrations, mediations, conciliations, all those things. This TRIPS agreements provide the framework or the guidelines of minimum protection criteria, legal mechanism for enforcement of intellectual property rights, and also the mechanism for resolving the dispute of intellectual property rights. So these TRIPS agreements act as a what? A guidelines. Act as a what? Guidelines. For which countries? Member countries. It sets out what is the minimum protection to be given. What to be given? For all the intellectual property rights by the member countries. Second one, it also provides the minimum legal mechanism to be given by the countries and also a mechanism for the what? Enforcement and resolving what? Dispute. Resolving the what? Disputes. Last one, special transitional arrangements for the what? Implementation of TRIPS provision. What is transitional arrangement? There is a gestation period given for the what? Member countries. For example, for developing countries. What countries? They can implement these provisions of the TRIPS in a phased manner because it is a developing countries. Yes or no? These are the main principles of what agreement? TRIPS. What is TRIPS? Trade related aspects of intellectual property rights. Last one is what? NIPR. Most important, based on this, they ask questions in the last examination, the previous exam. What is NIPR? National Intellectual Property Rights Policy. This is the policy framed by India with respect to intellectual property rights. What rights? Intellectual property. What is the first principle? This NIPR provides that there should be awareness among the world citizens of India with respect to how to create intellectual property rights, how to protect them, and how to enforce their legal right. That is the first principle. Second one, it encourages the creation of what? IP assets to the incubation center. What center? And also through financial assistance. What assistance? Financial assistance. What is the last second one? To modernize and strengthen the service-oriented IPR administration. What administration? IPR administration department of the intellectual property rights. Next one, support monetization and valuation of IP assets. So we have a course called as valuation course. What course? A CA, a CS or a CMA can do this valuation course once they qualify as a company secretary or a CA, where there are certain provisions to be followed for the purpose of valuation of intangible assets. For example, valuation of goodwill, valuation of shares. In the same way, there are certain criteria or rules to be followed for the purpose of valuation of what rights? Intellectual property rights. What rights, sir? Next one, strengthen the enforcement mechanism. That is a legal mechanism for enforcement of what right? Intellectual property rights. And the last one, to strengthen and expand human resources. What resources? Institutions, capacities for teaching, training, research, skill building and what? IPRs. Skill building in what? And ICSI is also one of the partner in this what? The goal of the national intellectual property rights policies. Clear? So these are the topics which we have discussed in detail. This is just a revision notes. What notes? These are the points which you must remember to write in the examinations. And for conceptual clarity, what clarity? And to present, like how to learn how to present the answers in the examination, you must refer to the what notes? A detailed notes. Clear with this? So I will be sharing both detailed notes as well as the what? Revision notes. Revision notes is for remembering the points, and detailed notes is for what? Understanding the concept as well as to get acquainted with the various legal terms. If your answer is too plain, they will not give the marks in the examinations. Even if they give marks in the examinations, it becomes difficult when you go to the practice or for internships. So you should get acquainted with the legal jargons. Along with that, you should know how to present the answers in the examinations. Clear with this? So now you guys tell me, what is intellectual property rights? It's a right. It's a creation of what intellect? Human intellect. Give me what are the types of intellectual property rights? Trademark, copyright, patents, geographical indication, industrial designs, trade secrets, and layout designs. What designs? And in your syllabus, you have how many chapters? 5 chapters. How many chapters? 5 laws. What is the first one? Patent. Second one? Trademark. Trademark. What is the first one? Second one? Third one? Fourth one? Geographical indication. Fifth one? Designs. That's it. 5 chapters, 40 marks. 5 chapters, 40 marks is the weightage. So you should study these chapters in detail. Clear? Then we started with what? Patents. What is a patent? You should remember this definition of a patent. What is a patent? It's a what right? Given by whom? To whom? For what? Protector this right. In exchange of what? Full disclosure of invention. Full disclosure of what? Which gives that person, or which allows him to exclude the other from what? Producing it, selling it, importing it, distributing the patented product. What product? One more time, one more time. Can we start? Let's start. What is the meaning of the patent? A statutory right. What right? Why it is called as statutory right? It is granted by the government. Very good. Given by whom? Government. Given for what? For what period? Limited period, unlimited period? What is a limited period? Very good. How many years? 20 years. How many years, sir? So it's a statutory right given for an invention, given for what period? Limited period of time. To whom? Who is inventing? The one who invents. By whom? In the exchange of what? Full disclosure. Everybody want disclosure? Of his what? Inventions, which allow him to exclude some other from what? Producing it, selling it, importing it, distributing the patented product. What product? You can't even import a patented product from where? Outside India. From where? Outside India. Are you guys clear with this? Yes or no? That is the meaning of what? Patent. Can we repeat one more time? What is patent? Statutory right. Given for the invention. By to for for a limited period of time in the exchange of his invention, and that allows him to what? Excludes other from producing it, importing it, distributing the patented product. Awesome. What are the benefits of patent? You get an exclusive right. What right? Exclusive right to produce it, sell it, import it, and also distribute it. Second one, you have a right to take what action? Legal action. What action? Patent infringement, you can file a suit in the court. Third one, right to, can you give a license to any other manufacturer? Who can give a license? Patent holder. And the person to whom the license is granted is called as what? Licensee. Called as what? Third one, exclusive license. What license? What is exclusive licensing means? Only he can use it. No other persons can use it. If I give an exclusive license to you, I cannot give the license to whom? Anyone else. That is called as what? Exclusive licensing. What licensing? That is also possible in case of what? Patent. Is assignment is possible in case of patent? What is assignment? Complete assignment of the what? Ownership of the right is called as what? Assignment. Right to make modification. Right to make what? Is there any provisions for making the modification in the existing invention? Possible or not possible? Possible. And can I get a patent for the new additions or new modifications? Yes. It involves what? Significant step. However, if you want a separate patent, that should have a significant step. If you don't want a separate patent, you just want a patent addition. What addition? There is no requirement of what? New significant efficacy. Significant what? Efficacy. If it is just an addition to what patent? Existing patent. What patent? So these are the benefits of what? Patent. Benefits of what? Then we discuss section 3 and 4, which is most important section in the Patent Act. Section number what? 3 and 4. What is section number 3 and 4? What cannot be patented? What cannot be? Just imagine those pictures and you guys tell me what are the inventions which cannot be patented. What is the first one? Frivolous inventions are inventions which are against the what? Natural laws. What laws? Can they be patented? Cannot be patented. After that, second one. Against the what policy? Public policy. Or morality. Or injurious to the public health or to the animals or the human beings. Correct. Then fourth one. Mere discovery. That flower, big flower, discovery of animals, discovery of flowers, discovery of the plants. Is it patentable? No. Fifth one. Mere a mixture of the existing product. If it does not result into increased efficacy, is it patentable? Not patentable. Not patentable. Then mere arrangement of things is not a patentable. Correct, right? Next one. Traditional farming methods. Patentable, not patentable. Not patentable. Then methods of new rules or methods of playing games. Are they patentable? No. Next. Surgical process, medical treatment, mathematical formulations. Are they patentable? No. Then nuclear, Oppenheimer, right? Oppenheimer in the examination. Very good. Yes. Oppenheimer is with respect to what? Nuclear technology. Can you patent a nuclear inventions? But you can patent the machines involved in the nuclear inventions. But you cannot patent the nuclear inventions. Correct, right? That's it. Computer programs, are they patentable? No. Clear? What are the criteria for patentability? How many conditions to be satisfied? 4 conditions. What are the 4 conditions? Novelty, inventive steps, industrial application, not section number 3 and 4. Let us quickly go to these points. What is the first one? Frivolous invention. What is the first one? Second one, invention contrary to the what? Public order, morality, prejudice to the humans, animals, or the environment. Third one, principle or theory, or mere discovery of what? Naturally occurring substances. Patentable, not patentable? Not patentable. Fourth one, mere discovery of what? New form without increased efficacy. You should remember this word. Without any what? Increased efficacy. Patentable, not patentable? Not patentable. Very good. Next one. Mere admixture. Patentable, not patentable? Not patentable. Next one. Mere what? Rearrangement of things. Is it patentable? No. Next one. Method of agriculture and horticulture. Next one. Invention with respect to treatment of humans and animals. Next one. Animals and plants as a what? Inventions. That breeding, remember, dog cannot be patented. Next one, mathematical business methods or computer programs. Next one, copyright. Is copyright patentable? No. It is copyright. You can claim a copyright for artistic work. What work? Next one, mental act. What act? Or method of playing a game. Is it patentable? No. Next one, presentation of information. Presentation of what? In tabular format or in diagrams. Is it patentable? No. Method of teaching? No. The method of teaching, is it patentable or not patentable? Not patentable. Next one, Patent on layout design? No. Traditional knowledge? No. Patent for nuclear energy generation process? No. So these are the inventions which are outside the scope of what? Patentability. Outside the scope of what? Patentability. Are we clear with this? Section number what? 3 and 4. Next we discuss the criteria for patentability. Correct, right? What are the conditions to be satisfied? How many conditions? What is the first one? Novelty. What do you mean by novelty? Something new. It should not be existence. So how to decide whether it is satisfy this, whether it is new or not? You just identify a person who is expertise in that industry. For example, if it is a gold jewelry, what jewelry? You go to a goldsmith. He is the one who is expertise in that industry. In that, to that person knowledge, if it is a new thing, it is considered as what? Novelty. Otherwise, it is not considered as novelty. It is considered as obvious things. Correct, right? So if you want to claim the novelty, like if a person is claiming a novelty for any invention with respect to scientific items, scientific goods, you will contact whom? The scientist. The government will identify the one person who is expertise in that industry, and to that person's knowledge, if it is an obvious thing, it is not considered as an invention. Clear? So what is the first condition? Second one, inventive steps, and it must not be obvious. If it is obvious, it is not patentable. Correct, right? Just mixing few things, it is not considered as what? Inventions. Third one, capable of what application? Industrial application, because these are industrial properties. Last one, it should not attract section number what? 3 and 4. These are the 4 conditions of patentability. You must remember these points to write answers in the examinations. Clear with this? Next one, registration of patent. Registration of what? We have discussed the step-by-step process. What is the first stage in registration of a patent? First of all, with whom you will file an application for registration of patent? Controller of patents. Controller of what? Online or offline? Online. Online or offline? Online application. Of everything happens online. We have a website called as IPR website. Registration of trademark, registration of patent, registration of copyright, everything happens online. And who perform this function of registration of IPRs? Company secretaries and advocates. Most of the advocates perform the functions of what? Registration of IPRs. And you can take an exam called as patent agent. What agent? What is patent agent? The one who assists in the registration of patents and also legal disputes. What disputes? In case of infringement of patent, infringement of trademark, you can represent your client before the whom? Court and the authorities. Are you guys clear with this? Yes or no? Let us discuss the step-by-step process for registration of what? Patents in India. What is the first step? Application to whom? Controller of. Controller of. So in that, who can apply for registration of patent? Inventive. Second one, assignee, in case of assignment of the patent rights. Third one, legal representative in case death of whom? The inventive. Death of whom? Inventive. One more time. Who is the first person? Person claiming to be the what owner? True and first inventor. Second one, any person being the what? Assignee. So if a person is claiming to be the assignee, he must attach the assignment deed. What deed? What is assignment deed? It's a contract by which what is made? Assignment is made. What is made? In case of assignment, there will be how many parties? What are the two parties? Assigner and assignee. Assignment deed should be on a stamp paper. What paper? And it must be registered. Must be what? Next one. Any person being a legal assignee and legal representative of who? Any deceased person. These are the person who are entitled to make application to whom? Controller of patent. After that, there is one more concept called as Patent Cooperation Treaty, which is important from the examination point of view. What is PCT? Patent Cooperation Treaty among the members of whom? WIPO, which assist or which helps a person to establish the priority date. What date? If an application is made under the PCT treaty, the date of application is considered as the date of application for any other country, means globally, provided the application is made within how many months? How many months? So it should be made within how many months of application in India? 12 months. How many months? Are we clear with this? Yes or no? How many months? If application is not made within 12 months, your application will be rejected. Deemed to be abandoned. Deemed to be. So let us discuss the provision with respect to patent cooperation treaty. It's an international patent filing system. What is the international patent filing system? PCT. Administered by whom? What is the first point you write in the examination if it asks question about PCT application? It is an international filing system. Administered by whom? What is WIPO? World Intellectual Property Organization. Is India is a member of WIPO? Yes. So can we make PCT application to the controller of patent? Yes. If I make a PCT application to the controller of patent, will I establish the priority date? Yes. Yes or no? Yes. Next one. PCT applications can be filed where? In India. An application filed with a provisional specification. What specification? And we know there are two types of specification, provisional as well as what? Complete. Tell me within how many months a person should file a complete specification? 18 months or 12 months? 12 months. 18 months for publication. 18 months for what? Publication happens after how many months? 18 months. But you can make a request for publication prior also. Clear? Next one. Disclosing the essence of the nature of invention, which helps to register the what? Priority of invention. Priority of the what? Invention. The date of PCT. Repeat. Date of what? Application in a member country is considered as the date of what? Patent application when the application is made in what country? Another member country. I want everyone to repeat this point. This is the most crucial point which is helpful for the PCT treaty. What is that provision says? Date of PCT application. One more time. Date of PCT application. In a which country? Is India as a member country? Yes. Will be considered as the what? Date of the patent application when the application is made in which country? Another member country. If I have made an application in India today, and if I make an application in USA after 6 months, after how many months? 6 months. What is the date of application? Today's date. And today's date is the date from which what is granted? Patent is granted. What is granted? Clear with this? Next one. Application should be made within how many months? These are the provision with respect to what application? PCT application. What is PCT, everyone? Patent Cooperation Treaty. That will help to establish what? Priority date. What date? So what system? International filing system. International for registration of patent, trademark as well as the copyright. For trademark, we have what system? Madrid system. And for patent, we have what system? PCT. Patent Cooperation Treaty. So can I register my trademark outside India? Yes or no? Under which treaty? Madrid treaties. Clear? Next one. We discussed about the specification. Discussed about what? I'm going in brief. I'm discussing only in brief because we have already discussed all these topics in detail in the yesterday's class. Correct, right? So while you make an application, you have to give a description of your invention. Description of what? And the description of the invention is called as what? Specifications. What is what? Every specification should be made in which form number? Form 2. Which form number? Form 2. And that form 2 can be either provisional or it can be complete. If it contains the complete disclosures or complete inventions along with the claim, along with the diagram of the invention, that is called as what specification? Complete specifications. If the invention is not ready, if it is premature, you can provide what specification? Provisional specification. What specification? First of all, what are specification? Specification is a techno document. What document? A techno legal document. What document? So this keyword must be there in your answers when you write the answers about specification. So what is specification? Techno legal. What legal? Document containing the what? Scientific and technical disclosures. One more time. What disclosure? And the claims for the what? Inventions. One more time. What is specifications? Techno legal document containing scientific and technical disclosures and claim for the what? In the form number 2. One more time. One more time. What is specification? Techno legal document containing scientific and technical disclosure claim for the inventions in the form number what? 2. Awesome. Brief description about the invention to secure the what date? Filing date. The specification helps you to secure the what date? Filing date. Contents of specification, there should be a description of invention. Description of what? Best method of performing the what? Invention. If it is a complete specification. What specification? Statement of claims, declaration as to what? Inventorship, that he is the inventor. Next one, a complete specification. What specification? Must be filed within how many months? If the complete specification is not filed within 12 months, what happens? Very good. Deemed to be what? Aborted. Application is deemed to be aborted. Are you guys clear with this? Can you guys write in the examination if they ask question about specification? One more time, tell me what is specification? No legal document containing scientific and technical disclosures and also claims for the inventions in the form number 2. It can be provisional or it can be complete. If the invention is not completely ready, you file what? Provisional specifications, and the complete specification must be filed within how many months? If not filed, what happens? Application is going to be aborted. So we got around 4 to 5 points right in the examinations. Then we have what specification? Complete specification. Same thing you'll write. If they ask question about complete specification, what you will write? A techno-legal document. What document? Containing scientific and technical disclosures and also the claim of the invention. The form number what? 2. May include drawings if necessary, must contain the what? Formal claims. What claims? A complete specification must be filed within how many months of how many months of provisional specification? Within how many months of provisional specification? 12 months. Otherwise, as early as possible to claim the priority date. What date? Priority date. I think I have discussed till here, I guess, like till point number 5. Yes or no? We should start with what? Publication of patent. Publication of what? We'll discuss the provision with the help of the short notes. Once we remember this, we'll go for the detailed notes for understanding the question and the answers format. Clear? Let's start. Publication of what? Just imagine the procedure. What is the first step? Preparation of application. Preparation of what? Who can make an application? Inventing, assignee, legal representative. They will make an application. There are 2 types of application. Normal application, PCT application. One more time. What application? PCT application for what? Claiming the patent globally. More than 1 countries. Correct, right? Then, along with the application, you provide what? Provisional specification or complete specification. What specification? Or complete specification. If it is provisional specifications, you should file complete specification within how many months? 12 months. How many months? Now the specifications are filed. What is filed? Once the specifications are filed, the patent officer, that is the controller of patent, must publish this application form to the information of the public to give an opportunity to the public to raise their concerns or objections. I repeat, the application of the inventee must be published by the controller of patent to seek objections from the public. This publication to be made in the journal maintained by the controller of patent, and this publication should be made after the expiry of how many months? 18 months. How many months? If the publication is, if there is no request made, what made? If there is no request made by the applicant for the publication of the application within 18 months, the application automatically published in the what? Journal. After how many months? 18 months. How many months? Is there any provisions for the request by the applicant for the earlier publication? Yes. Only if he has filed what specification? Complete specification. What specification? Only after filing complete specification that specifications will be published to the public to seek their objections. Are we clear with this? And what is the purpose behind publication? To seek objections from whom? Public. On various grounds. What grounds? If this invention is similar to the existing invention, the existing patent holder, what you can do, you can raise the objection to whom? Controller. To whom? And what controller will do? He will intimate this to whom? Inventee. Then he has to make the correction about that application form. Are we clear with this? Yes or no? Let us discuss the provisions of publications of what application? Patent application. What application? What is the primary objective? Primary objective of what? Is to make the what? Patent application details publicly available. Publicly? Simple one. Next one. Application for the patent is not open to the public. Is it open or not open? Not open to the public before the expiry of how many months? From the date of what? Fine. Keep all these timeline for writing answers in the examinations. It will not be open to the public for inspections up to how many months date of filing? 18 months. How many months? Next one. Patent application is published automatically in what? Official patent journal on the conclusion of how many months? Is there any provisions for earlier publication? Who can make a request? Inventee. To whom? Controller. He can ask for the earlier publications. Clear? Next one. And applications can be made for early applications only if the complete specification has been filed and the application to be published within how many months? From the date of such request. So if there is a request for the earlier publications, the controller of patent should publish that application within how many months of request? 1 month. How many months? Next one. In the following cases, application is not published. Most important for the purpose of practical questions in the examinations. In what scenario application should not be published? First one. If there is a secrecy direction. What direction? Under section number 35 of the Patent Act. If the invention is with respect to the defense item. What items? The central government has the power to give a direction to maintain the what? Secrecy. In that situations, application of the application should not be published. What is the first scenario? Secrecy direction under section number what? 35 is in force. Unless until the direction is in force, it cannot be published. Once the government revoke the directions, it can be published. That is the first exception. What is the first exception? Secrecy directions. Everybody. Under section number 1 is in force, especially with respect to the defense inventions. Second one, application is abandoned. Tell me when the application is abandoned. If the complete specification is not filed within how many months? What happens to the application? Application is abandoned. If application is abandoned, where is the question of publication? Second scenario, simple one. Third one is what? Application is withdrawn. You have a right to withdraw the application 3 months prior. 3 months what? To the date of what? Publication. Due date of publication. Due date of what? Now you guys tell me, what is the due date of publication? 18. So before how many months? 15 months. 15 months is the last date by which you can withdraw your application. And these are the 3 cases. How many cases? Where what is not required? Publication of application is not done by the controller of patent. And what is the purpose of publication? Object to inform the public and to seek the objections from the public. Principle of natural justice. Principle of what justice? Natural justice. On and from the date of publication of the application for the patent and until the date of grant of the patent in respect of such application, the applicant shall have a like privileges and also what? Right. From the date of what? Publication. From the date of what? For the patent and until the date of grant of patent. Once the patent is published, what is published? A patent application is published. Until the time you get a grant of patent, you will have a similar right. What right? As that of a patent holder. What holder? You are not the patent holder yet, but still you will have a rights of a patent holder. If somebody infringes your patent, you can file a case only when? After you get the patent. Got it? You will have a similar right of a patentee during the period of what? Date of publication and date of grant. Date of what? Grant. But it doesn't mean you will have a right to file a case during this period. You can only file a case after what? Grant of patent, grant of what? And when you file a case after the grant of patent, you will file a case for injunction to prevent him. Injunction to what? Prevent him, compensation, the infringement of patent, and also disgorgement or account of the profit made by selling the infringed patented product. So it's a retrospective right. What right? So you get the patent right from the date of what? Application itself, but you get the right of the patent from the date of what? Publication.
Sir, you told it, you can't file until the patent is granted.
Correct.
Like, so in the next point, it's given that until the patent has been granted, you can file this.
Where?
Next point.
That is a mistake. Like suit cannot be filed until the patent has been granted. Mistake. होता है बड़े बड़े देशों में हाँ होता है आ जाते हैं mistakes आ जाते हैं. So suit cannot be filed. What cannot be filed? Until what is granted, patent has been granted. Because see, simple says simple. In the jurisprudence, knowledge of law, only when you have a right, you can claim the protection of a right. I just made an application to get a right. When I don't have a right, how can I go to the person saying that there is an infringement of right? So law says wait for the date of what? Grant of patent, because you're not sure. What if your invention is frivolous or somebody claims that invention as his invention? Are you guys getting it? Yes or no? That is why you have to wait till the date of what? Grant of patent. Grant of what? No patent shall be granted before the expiry of how many months? From the date of what? Publication of application. Publication of. This will be a waiting period of how many months? 6 months. How many months? Are you guys clear with the timeline now? What is the purpose of publication? To inform the public and seek what? Objections. Within how many months? Can there be a request for earlier publication? Within how many months there should be a publication? 1 month. And within how many months a person can withdraw his application? 3 months prior to the due date of publication. What are the 3 scenarios in which publication is not mandatory? Secrecy direction is given by the government, section number 35. Abandonment, and the last one is withdrawal. Withdrawal of the application. Now tell me, there are 2 persons, joint applicant. What applicant? Out of those 2 persons, 1 person want to withdraw the application, other person does not want to withdraw the application. What happens in this scenario?
So one person can accept the.
There is a dispute now. You both made a patent application to me, joint applicant, and now you are applying for what? Withdrawal of applications. So in this situation, what will happen? They have to come under an agreement. If they don't come under an agreement, they should go to where? Court. Whatever the court says, I will follow it. Because it's a joint application. A joint application can be withdrawn only with the consent of whom? Both the applicant. Are we clear with this, everybody? With respect to the what? Publication. Let us just discuss how to present the answer if there is a question based on what? Publication. Question based on what? I want your assistance while reading these provisions, because not reading. Let's start. Section number here. Section number 11. Section number what? Section number. Everybody, section number. So what type of questions might come in the examination based on publication of patent application? What is the first one? Explain the provisions. Everyone read. Explain the provisions with respect to publication of patent application and its effect. Can you write answers for this in the examination? We have more than 5 points read in the examination. Yes or no? Next one. Practical question. What question? Ramesh, an inventor, filed a patent application in India on 1st January 2025 for his invention, a smart umbrella that charges the mobile phones using a what? Solar energy. Good invention. Does it satisfy the 4 conditions? What are the 4 conditions? Novelty, inventive step, industrial applications. Section number 3 and 4 is not. Very good. He claimed priority from the earlier patent application filed in the United Kingdom on what? 1st October 2024. So he filed application in India on what date? 1st January 2025. But he is claiming the priority from what date? 1st October 2024. This is possible only if it is not application, PCT application. If he has made a PCT application in UK, then he can claim this date as a what date? Priority date. Possible or not possible? Is this application made within 12 months time frame? Yes or no? Both conditions are satisfied. Explain with reference to the provisions of the Indian Patents Act when Ramesh Indian patent application will be published. When it will be published within how many months? 18 months from what date? 1st October 2024 or 1st January 2025? 1st October 2024. Very good. How many months? 18 months. This type of question might come in the examination, practical question. Yes or no? Because it is how many months per date of application? How many months? And date of application is the date when what is made? PCT application is made. Clear with this? Next one. How a patent specification is prepared? When is an application for patent is published as per which act? Patent Act which year? 1970. This was asked in June 2025 examination for how much? 6 marks. Easy question. How what is prepared? Patent specification is prepared. We discussed what is patent specification. What is patent specification? A techno-legal document containing scientific and technical disclosure and claim for the inventions made in the form number 2. That is called as what? Specification. There are how many types of specification? 2 types. Provisional and complete. Clear with this? Yes or no? If it is a practical question, how to present the answers for this? I want you guys to read along so that it becomes easy for me also, so that I can take some rest. Correct, right? Read. Everyone should read. In India, after the patent application is filed with the Indian Patent Office, it undergoes a formal publication process. The primary object of this application to make the details of the publication publicly available, thereby informing the public about the existence of the patent application, its claim, and its specification. Timeline. An application for patent is not open to the public before the expiry of 18 months from the date of filing or date of priority, whichever is earlier. Whichever is in our example. What was earlier? Priority date was earlier. From that date, how many months? 18 months. At the end of the period, as mentioned above, application is published in the what journal? Except in how many cases? What is the first one? Secrecy direction. Application is abandoned. Application is withdrawn. How many months prior? 3 months prior. Can there be an application for early publication? Yes. Within how many months? 1 month from the date of such request. What is the effect of publication? After publication of the application for the patent, the depository institution shall make biological material mentioned in the specification available to the public. If there is any biological material available, it has to be displayed. It has to be what? For the inspection of the public. Second one. On and from the date of publication of application for a patent and until the due of date of grant of patent in respect of such application, the applicant shall have the what? Like privileges and the rights as if the patent for the invention had been granted on the date of publication of the application, provided that. Why do we use the word provided that? To add condition to a provision. What to a provision? To add first condition, use the word provided that. To add second condition, use the word provided further that. To add one more condition, use the word provided also that. To add one more condition, it continues. Also that. Right? Also that. That's it. So provided that, provided further that, provided also that. These are called as provisions. Called as what? What is provisions? Provisions are the clauses which are used to add a condition to a provision or a qualification to your provisions. Provisions. Are we clear with this? Yes or no? No patent shall be granted before the expiry of how many months? From the date of what? Publication of the applications. Clear? Got an idea how to present the answer for theory question as well as what question? Practical questions. These are the possibility of questions based on publication. Based on what? Clear with this? Next topic. After publication, what is the next step? Examination of application. One more time. Who should make a request for examination of application? Applicant. Who should make a request? To whom? To whom? Who should make an application? Who should make an application? Applicant. To whom? For what? Within how many months? From the date of what? Priority of the application, or from the date of what? Filing of the application, whichever is. Publication within how many months? How many months? Request for examination from the date of application or priority date, whichever is earlier, whichever is. If no RFE is filed within what time? Stipulated time. Application is considered as what? Withdrawn. So what is the time limit for filing a request for examination? 48 months. How many months? From the date of publication of application or from the date of application? Is it from the date of publication of application or is it from the date of application? Application. Application date is different. Date of publication of application is different. How many months time? 18 months. For examination of application, 48 months. How many months? In case of secrecy direction under section number 35, the RFE may be filed within the what? Prescribed time. After what is revoked? Secrecy direction is revoked. Next one. On receipt of RFE, the controller refers the application and all the documents to whom? The examiner. To whom? Examiner. He will assign an examiner to examine this application form to check whether it satisfies all the four conditions. If it does not satisfy all the four conditions, he will give a report to the controller and controller will give a what? First examination report. What report? FER to whom? Applicant, and the applicant should put the application in order by satisfying those conditions referred in the FER. Are you guys getting it? You make an application to whom? Control. With what specification? Provisional or complete specifications. Then what will happen? Publication will happen. What will happen? Once publication happens, then you should make a request to the home controller. For what? Examinations. For what? Then what controller will do? He will appoint an examiner. What examiner will do? He will examine the application form and give report to whom? Controller. And if there is any discrepancies found, if there is any if there are any violation of the provisions of the law, then the controller will give a first examination report to whom? Applicant, to correct those what? Mistakes. And the applicant should put that application in order within 6 months. How many months? Extendable by how many months? 3 months. Again, how many months? 6 months in extraordinary situations. Clear with this? Next one. The examiner prepares the what? Prepares the what? Report. After that, what will happen? Examiner conducts the searches to identify what art? Prior art. What art? If there is an existing art means what? Existing inventions which is already patented. He will search for that. There is an international searching system which is provided by the WIPO. Then whether the invention is already known or prior publication outside India. If the report is adverse, the controller communicates the objections. Who communicates the objection? Controller, and provides what? Opportunity of being heard. This is the principle of natural justice. Principle of what justice? Wherever there are discrepancies or before you pass any order, you must give an opportunity of being heard to the whom? Other person. So the controller will give an opportunity of being heard to the whom? Applicant. Then what will happen? If the application does not comply with the act or a rules, he may refuse the what? Application or require the amendments. Require the what? If he requires the amendment, it is the duty of the applicant to put that application in order within how many months? 6 months. How many months? The applicant may request the controller to post the date of application, but not beyond how many months? 6 months. The date of what filing? Actual filing. Means you can ask the controller to post date the date of application for your own advantage, because you get extra 6 months of time of patent rights. So that post dating is possible only for how many months? 6 months. How many months? Who can request? Applicant. I can request the controller to post date my applications for various compliance provisions, and also to get more number of years for the protection of what? Patent. But the maximum period of post dating is how many months? 6 months. How many months? Clear with this? Yes or no? These are the provision with respect to examinations. Who does the examination? Appointed by whom? Who should request for examination? Within how many months? How many months? From the data. What if there is an adverse report? What report? What controller will do after giving what? Opportunity of being heard. What he can do? Either he can refuse the application or ask for modification or amendment. If there is a request for amendment or modification, applicant should put that application in order within how many months? 6 months. Can you ask for post dating the application? Yes. Up to how many months? 6 months. These are the provision with respect to what? Examination of application. Examination of next one. Next one. Power of the controller. Power of whom? During the examination of what? Patent application. This is the one more important provision or one more important section. Before I go to this, let us discuss the provision with respect to examination of application. Examination of what type of question might come in the examination? What is? What is in patent process, and also explain the provisions involved. What is examination? It's a critical step. What step? Where the patent office evaluates whether the invention meets the what? All legal and technical requirements for granting the patent. Provisions we discussed: request for what? Examinations, examination of applications, then search for anticipation, that is prior art, consideration of examiner's report, power to refuse or requires a what? Amendment, dating of application and post dating of the application. Up to how many months? How many months? Clear with this? These are the provisions with respect to what? Examination. While doing this examination, what are the powers of controller? There can be a question in the examination based on these provisions. What are the powers of the controller during the examination of what application? Patent application. What application? First one, power to refuse. Power to what? Or require the in what matters? Certain matter. This is the first power of who? Controller. What controller? Patent controller. Second one, power to make order respecting division of application. Division of what? If application relates to more than one invention, if there are two inventions for which one single application is filed, then after examination, the controller can ask for what? Division of application. Division of what? And to make two separate applications. Clear? This is the one more power of who? During what? Examination. During the what? Or after examination. After what? Examination. Third one. Power to post it. Power to what? But maximum how many months? How many months? Power to post date the application, but not later than how many months? 6 months. Power to order amendment of the complete specification if the invention was what? Anticipated. You may also order for the amendment of specification. Amendment of what? Specification. Power to pass certain orders in case of what? Potential infringement. Potential. Last one, most important one. Power to make orders regarding the substitution of applicants. What is that? Substitution of applicant means replacing the existing applicant, and that order can be made in the following scenarios. What is the first one? Due to what? Assignment or agreement between the applicant and the new person. Second one joint applicant dies. In that scenario, there can be a what? Substitution of applicant. Substitution of what? Last one, dispute between the joint applicant. And as per whatever the order is made by the court, the controller will replace the existing applicant. Clear? These are the powers of the after. What is the first one? Power to refuse or requires the amendment. Second one, division of application. Third one, posted. Not more than how many months? Power to order what? Amendment. Of what of specification? Complete specification if the invention was anticipated. Power to pass certain orders in case of what infringement? Potential infringement. And most important one, power to make order regarding the what? Substitution of the applicant. How many scenarios? Last bench boys, how many scenarios? Three scenarios. What are the three scenarios? What is assignment? What is assignment? Transfer. So I have assigned my right to her. Now she can apply for what? Substitution. When the application is received, they can substitute the new applicant in the place of the old applicant. Second one joint applicant dies. Now the legal representative of the deceased joint applicant can be replaced. Correct, right? Or he may continue with the surviving joint applicant with the consent of the legal heirs of the deceased joint applicant. Means there are two joint applicants. One dies. First option is the legal heirs will join as a what? Joint applicant. Second option is what? By an application by one of the joint applicant with the consent of the legal heirs of who? Deceased joint applicant. The applications can continue in whose name? Surviving joint applicant's name. This is the one more option available. Are you guys clear with this? Yes. He's legal representative. What if he also dies? He's legal representative. What if doesn't have a legal representative? His brother, paternal, even nobody is there, the government will take over. Government will be waiting for those scenarios where nobody claims the property, so government will take over the property. There is one property in Connector Road. Near that one lake is there, right? Before Dynamism College, that forest, Tajgodi estate, that actually owned by a foreigners. Two foreigners, they came to India to explore the art. They created a trust. That Tajgodi estate is formed under a trust. They wanted to develop the trust, so they died without having any legal heirs. So government proposed to construct buildings over there. Because they took over the rights of the property and they thought of constructing the buildings over there, but that was challenged by the activists, and court held that even though the right belongs to the government can only administer it for the purpose for which it was created by the deceased. So that can be used only for what purpose? Promotion of art. Even the government has the ownership, doesn't mean they can do whatever they want. They should carry out the object of the deceased persons. Anyway, next one. Are you guys clear with the powers of the controller? Yes or no? Let us discuss this provision. What type of questions they come in the examination? What are the powers available to whom? During the what? About application? Patent application. What is the first one? Power to refuse or require amended application in what matter? After giving opportunity of being heard or before giving opportunity of being heard? After giving opportunity of being heard. Second one, power to make orders respecting the what? Division of application. What of application? Third one, power to make orders respecting the what? Dating of application. Not more than how many months? Alright, everybody, how many months? Very good. Power of the controller in what cases? In the cases of anticipation. Controller has the power to order amendment of the complete specification if the invention was what? Anticipated. You can ask for a new specifications. Prior art. What is prior art? If it is already published or already claimed. Next one. Power to pass certain orders in case of what infringement? Potential infringement. And the last one is what? Most important one. Substitution of what? Applicants. In how many cases? What are three cases? Claimant is entitled assignment or agreement. Second one. Third one, when there is a dispute between the joint applicant as to the manner in which application should be proceeded with. In that scenario, you may ask the parties to go to the court and get it resolved, and whoever gets the order of the court, in his name the application will continue. Clear with this? Yes or no? Then we have section number 19. Section number what? 19. Section number 19. What is infringement? Violation of what? Rights of what holder? Patent holder. What is patent? Arey, bolo, what is patent? Statutory right given to the inventor by the government for a limited period in exchange of complete disclosure allows him to manufacture, sell, distribute, import, which gives him an exclusive right. Correct, right? So if any other person starts manufacturing it, distributing it, or selling it, or importing it without a license or assignment with a patent holder, it is called as what? Infringement of patent. Called as what? What is infringement of patent, everybody? Violation of the exclusive right. What right? Of what holder? Patent holder. In case of patent infringement, the patent holder has the right to sue the infringing party to get a relief and also what? Compensation for the damage caused. What cost? That is what called as potential infringement or patent infringement. Are we clear with this, everybody? What type of question might come based on this? What is the question? What is meant by potential infringement under which act? Which act? Second type of question. Explain the power of the controller in respect of application for a patent which has substantial risk of infringement. If a patent application has a substantial risk of infringement, what he can do? Either he can reject it, ask for modification of the entire specification. That is the power of whom? Power of whom? Controller. Let's read the answer. Can you read the answers? Patent infringement is the violation of exclusive rights of the patent holder. Which section number? Which section number? That is what most important. What does it grant? Exclusive right. What right? Are to exclude whom? From making, using, offering, selling, manufacturing it. And if anyone does any of this activity, it amounts to what? Infringement. Then who can file a case? Patentee can file a case. Continue. Thus, any activity which violates such monopoly can be considered as a patent. In cases of patent infringement, the patent holder has a right to sue. What cost? Damage. Sir, why should we read this much when we have this one, sir? Why? Because you need to write at least 8 to 9 points in the examination to get a good marks. Correct, right? And when you read this, some points will be in the subconscious memory. Are you guys getting it? So this you should remember for sure. There is no exceptions for remembering these 2 points. Along with that, we should remember 2 or 3 points right in the examinations. Clear with this? Next one, last question for this topic. Explain the With respect to insertion of reference to whom? Another patent right. This is most important, most important. I want everyone to concentrate. See, I make an application to the patent office, controller of patent. Once I make an application, what they will do? Examine the word application, patent application. In that examination, if they find that my invention involves an infringement of an existing invention, means it is accidentally touching the word existing invention, then in that specification, in that word specification, what can be made? A reference can be made. What can be made? With what invention? Existing invention. What invention? Or other specific. That is called as reference to the other invention. Reference to the what? Another inventions. Important provisions. I want everyone to concentrate. Concentrate. If the invention is what? In a new applications. Repeat. If the invention in a cannot be used without infringing an existing patent. What patent? The controller may direct the applicant to insert a reference to that patent in the complete specification. So when the controller can order the patent applicant to include a reference in the complete specification to the existing patent, when that new application cannot be what? New invention cannot be what? Used without infringing an existing patent. I repeat. Question is, when the controller of patent direct the applicant to include a reference in the complete specification to the existing patent, when the new invention cannot be worked without infringing the existing patent. In that scenario, who can make an order? To do what? To include a reference. In which document? Complete specification. What specification? So what patent? Existing patent. What patent? Now you guys tell me the answer. I'll ask one more question. I want answers from everybody. Listen. When controller can order for insertion of reference in the complete specification to the existing patent, when the new invention cannot be worked without infringing the existing patent. Got it? I'll ask one more question. If a new invention in the application cannot be worked, if new invention cannot be worked without infringing the existing invention, what order the controller can pass? The controller can pass an order to include a reference in the complete specification to the existing patent. What patent? Are you guys clear with this? One more question. When the controller of patent can direct or pass an order to include a reference to the existing patent in the complete specification of the applicant, when the new invention cannot be worked without infringing the existing patent. Now you guys clear with this? When we do the reference to the existing patent, yes or no? Next one. This reference act as a what notice? Warning the potential users or licensees about the possible infringement risk. There can be a chances that the patentee can file a case against the licensees or the inventor for infringement of patent. The applicant can avoid, this is the most important provision, inserting the reference if there reasonable grounds to challenge the validity of what? Other patents claim, means they have a reasonable grounds to challenge the existing patentee's claim. Second one, makes amendment in their what? Own specification to avoid the infringing of what? Other patent. So the two scenarios where there is no need to do what? include the reference to the existing patent. Last one, deletion of reference. Deletion of what? Reference is already included. Patent is granted. Even at a later stage, you can get it deleted. In how many cases? 4 cases. How many cases? What is the first one? If the other patent is revoked. There's a concept called as revocation of patent with a controller. If the patent of the existing inventee is revoked, then the reference can be deleted. Second one, if the other patentee ceases to be in what? Other patent ceases to be in what? Force. Tell me when a patent ceases to be in force. Well, very good. After how many years? Everyone after how many years? Then there is no requirement of having a reference to the what? Existing patent. You can delete it. Third one, if the other patent specification is amended by what? Deletion of the claim. Deletion of the what? Means other persons delete his claim in the specification. Then we can also delete the reference made. Last one, if the code or controller declares the other patent claim as what? Invalid. In these 4 situations, we can get that reference made in the complete specification deleted. Let me ask a question. Listen. First of all, who can pass order or directions for insertion of reference in the complete specification? When he can pass that order? When the invention in the application cannot be worked without infringing the existing patent. In which document that reference to be included? Complete. When it is not required to be included? If the applicant can show that he has a reasonable grounds to challenge the existing patent's claim is invalid. Second one, if he amends his specification, amends is what? To make it not an infringement of what patent? Existing patent. What patent? Once a reference is made, what is made? Can it be deleted? In how many scenarios? How many scenarios? What is the first one? Patent is revoked. Existing patent is what? Revoked. Second one? Ceases to be in force. 20 years. Third one? By deleting the what? Claim. And the last one, if the court or the controller declares the patent claim as what? Invalid. As what? In these cases, there can be a deletion of reference made to the existing patent. What patent? Existing patent. Are you guys clear with the provisions? Yes or no? One more time, one last time. Tell me when the directions can be given. When the new invention in the application cannot be worked without infringing the existing patent. That is when there is a question of inclusion of reference to the existing patent. What patent? Existing patent. Are we clear with this? So based on this, what type of question might come in the examinations? Can you guys read the provisions, please? Read. If during the examination or investigation, the controller finds that invention claim in a new application cannot be worked without a substantial risk of infringing a claim of another existing patent, the controller may direct the applicant to insert a reference to that existing patent in the complete specification. That is what even we remember now. Correct, right? Your answer must have all those 3 key points. Who can make directions? In what document reference is included? In what scenario it is made? 3 important terms. Clear? Then what happens? This act as a what? Public notice and warns the who? Potential user or the licensees about the possible infringement risk. The applicant can avoid the insertion of this reference if they show reasonable grounds. What grounds? To challenge the validity of the other patent's claim, or they amend their own specification to avoid the what? Infringing the other patent. Deletion of reference. Deletion of what? By making an application to the controller, a reference to the other patent can be deleted. In what circumstances? Following circumstances. Means there is already a reference included, we can get it deleted by making a what? Application. To whom? Controller. In how many scenarios? 4 scenarios. How many scenarios? What is the first one? If the later the other patent is revoked. Second one, other patent ceases to be enforced. Third one, other patent specification is amended by deletion of the claim. And the last one, if the court or controller declares the claim of the other patent is invalid. Clear with this? This is with respect to insertion of reference to the existing patent. What patent? Existing patent. And this concept I've already discussed. Substitution of what? Applicants. Substitution of what? One more time. Substitution of what? Who can pass this order? Who can pass an order for substitution of applicant? Who can pass? Control. In what scenarios? Let us discuss the scenarios. Before the patent is granted, someone claims to the what? Written assignment. What assignment? Or agreement made by the applicant or by operation of law. What of law? First one, I hope you guys clear with the first situation. What is the first situation? Assignment. I have made an application, but I have assigned the rights to her. Now she makes an application to the controller saying that I am the assignee. So you please substitute my name. To whose name? Applicant name. In that situation, what controller will do? He will order for substitution of name, provided she provides the valid document. What document? Valid document. What is that valid document she must provide? You are the controller. Everyone concentrate here. Listen. You are the controller. She is the applicant, or he is the applicant. Organic brother is the applicant. So he is the applicant. He assigned his rights to me. How can he assign it? He should enter into a contract with me. That is called as what deed? Assignment. Assignment. What deed? Assignment deed. Should be on what paper? Assignment deed is made. I have an assignment deed. What I'm supposed to do? Okay, register. Then what I'm supposed to do? I should apply for what? Substitution of my name. In who? In the place of whose name? Applicant name. I should submit this document. And in this document, there should be a clear description of invention. Clear description of what? Invention, as well as the parties, as well as the application number. What number? Application number. On receipt of this application, what controller will do? He will substitute the name of the assignee in the place of who? Original applicant. This is the first situation. Second one is what? By agreement. By what? Third one by operation of law. What of law? Give me example for this.
Mr. Legal Administrator.
Okay.
Or after the
when the administrator will come into picture. Trust me. Or in case, listen. Let's say I am the one who has made an application for registration of patent, but pending application, I become insolvent. If I become insolvent, what happens in that scenario? All my rights are invested with whom? With the receiver, official receiver. Have you heard the word official receiver or administrator? Whenever a person claims an insolvency, the court will appoint a whom? Official receiver. What receiver? Now he can make an application by operation of law. What of law? Operation of law. In case of death of the original applicant, the rights transferred automatically. That is as per the law. To whom? Legal heads. Now the legal heads can make an application to whom? Controller for substitution. For what? Are we clear with these 3 scenarios when substitution can be ordered? What is the first one? Everyone. Second one. Third one. What are the conditions to be satisfied for an application made for substitution? What is the first one? Invention is clearly identified. In the assignment or agreement, assigner has what? Acknowledged in writing. You should have acknowledged in writing to assign the right. Third one, death of a joint applicant before the grant on the request from the joint applicant and also approval of whom legal heads, applications can be proceeded in the name of whom? Survivor, the only one who is left. Clear? So these are the provision with respect to what? Substitution of names or applicants. Can we read these provisions, please? I want everyone to read this legal language. Read. Start. Or by operation of law that they would be entitled to patent itself or the applicant interest in it or to an undivided share in it. Then the controller is satisfied, he may direct that the application shall be proceed name of the claimant or in the name of the both claimant and the original applicant as the case may. This is the order who can pass, controller can pass. Clear? Next one. If there are two or more joint applicants, an assignment or agreement made by one cannot lead to substitution without the consent of other joint applicant. Based on this single point, there can be a practical question in the examination. If two persons have made an application, the assignment can be made only with the consent of who? Both of them. Clear? Next one. The controller shall not, by virtue of any assignment or an agreement for the assignment, direction for the substitution of applicant unless the invention is clearly identified, assigner as what? Acknowledged in writing, claimant's rights are finally established by the court decision, or the controller himself gives the direction. Only in if these conditions are satisfied, there can be an order for substitution. Last one, we already discussed this point. In case of death of a joint applicant, on the application of the surviving joint applicant and also the consent of whom? Legal heirs of the deceased joint applicant, the applications can continue whose name? Survivors. Whose name? These are the provision with respect to what? Substitution of applicant. Substitution of what? Applicant. Clear with this? Yes or no? Now, who can request? Let us go back to the procedure for getting the patent. What is the first step? What is the first step? To whom? Everyone should answer. To whom? By whom? Who is an applicant? Or legal representative of the deceased. With what specification? Or if provisional. Within how many months we should file a complaint? How many months? Can there be a PCT application? What is PCT application? International Filing System. What system? To establish what date? Priority date. You should file the application in the member country within how many months? 12 months. How many months? Then what is the next step? Request for publication. Within how many months? From the data? From the data application or the data priority. Data, whichever is. Can there be a request for earlier publication? Within how many months you should make a request? Within how many months you should make a request? 15 months. 15 months of the date of what? Application. And on the request, the controller shall order for publication within how many months? 1 month. What is the reason of publication? Inform the public and to seek the objections if any. After that, there should be an application by whom? Applicant. To whom? For what? Then what controller will do? Appoint. What he will do? Conduct the examination and he'll also do the search for the existing art or a prior art. And they give a report to whom? It can be what report? Adverse report. If it is an adverse report, what controller can do? refuse the, after giving what? Opportunity of being heard, he can refuse the application or order for amendment or modification. In that scenario, the amendment should be made within how many months?
6 months.
How many months? That is what we're going to discuss now. Time limit for putting the application in what? Order. For what? Grant. Within how many months? Extendable by how many months? If the application is not put in order within this time frame, what happens to the application? Application needs to be abandoned. Yes or no? What is the time frame? What is the time frame? Within how many months? From the date of what? What is FER? Can it be extended? Up to how many months? By complying with what? All the requirements imposed under the what? Act. You should put the application for what? In order. Application in what? Because there are some discrepancies found by the controller, you need to put that application in order by complying with the rules. Within how many months? 6 months. If the failure is beyond their control, beyond their what? Can they ask? They must do the same to whom? Controller for extension. For what? Extension. Further extension of 6 months. If any appeal to the High Court is pending, what is pending? Appeal to the High Court. Not High Court is pending. What is pending? Appeal. To whom? High Court. The time period for the compliance is extended until the date decided by whom? High Court. High Court order overrides this 6 months provisions. Clear with this? Tell me, what is the time limit to put the application in order? How many months? If you put your application in order within 6 months, then what will happen? Patent is granted. What is granted? Patent is granted. We are done with the procedural formalities. What formalities? But there is one more situations. The objections for grant of patent. On what grounds a person can raise the objections? Same like section number 3 and 4. Section number what? 3 and 4. Clear with this? Let's discuss this one. Opposition to the what? Patent. On what grounds a person can oppose grant of patent? What is the first ground? What is the first one? Give me an example for this. Can anybody give me an example for this?
Giving bribe and getting the patent.
Okay, giving the bribe and getting the what? Patent. That is the first situation. For that, we can punish the one who has given the patent, but again I can apply for the patent. One more situation. What if I am a employee of your company? I secretly copy the inventions made by the company and I get the patent registered in my name. What I have done here? Fraudulently obtained the patent. In that situation, what can be done? It can be challenged. Who can challenge it? I am the employee, you are the company, I copied your secret, got the patent registered. Now who can I made application for registration of patent. Who can challenge it? Company. Clear? So this is the first ground for the opposition of what? Patent. What is the first one? Wrongful. I can't hear you guys. Everyone, what is the first situation? Wrongful. Second one? It is already in existence. Someone has already published where? Outside India or inside India. But however, if the prior publication was made in an exhibition and if the application is made within how many months? 12 months. How many months? Then it is not considered as a prior publications. Means if it is a government exhibitions and in that exhibitions, if I exhibit my inventions and after exhibition, if I make an application within how many months? 12 months. How many months? It is not considered as a prior publication. Other than this scenario, if an invention is published outside India or in India, on that particular ground, can it be challenged? Can it be challenged? What is the second scenario or second ground for challenge of patent? Prior. First one. Boys. One more time. Girls. ಏನಾಗಿದೆ ಈ ಸಮಾಜಕ್ಕೆ? I think Narendra Modi should change the slogan. Beti bachao, beti padhao badu. Beta bachao, beta padhao. Boys, like, what is this, boys? Boys should always be boys, huh? What is it? Why should answer. Why should dominate the class? Tell me, what is the first situation? Very good. Wrongful obtainment. Second one. Prior public. Second one. Third one. Prior claim. Means someone has already made an application for registration of patent, and then you made an application at the later stage. It can be challenged. Third, fourth one. It is already used by the public, then it is cannot be patented. It can be challenged. Fifth one, there is no inventive step. It can be challenged. Sixth one, non-patentable subject matter. We know what are the subject matter which are not patentable as section number 3 and 4. Next one, insufficient description. You should make a complete disclosure of the patent. That is why we give you the patent right. Correct, right? If you have made an incomplete disclosure, can it be challenged? Can it be opposed? Yes. Any person can oppose that application form. Clear? Next one. Non-disclosure or false disclosures. If you don't disclose the complete information or you make a false disclosure, on that basis, what can be done? Oppositions can be raised. Next one. Time limit. What is the time limit for filing the convention application? You have filed an application in UK 2 years back, and then later you file an application in India. In that situation, can it be opposed? Yes or no? Because you should make an application for registration of patent within how many months? 12 months. From what application? PCT application. How many months? How many months? Next one. Application fails to disclose or incorrectly states the geographical source of the biological material. Means you have invented something by using a biological discovery, like a product. You have invented a medicinal plant in Amazon forest. Can you get a patent for that? No. Why no? I use that medicinal plant. I use that medicinal plant, and by adding few more ingredients, one more time. Listen. Flow. I discover a medicinal plant in an Amazon forest. Can I get a patent for that? Yes or no? But I use that biological product, mix it with something else, which gives an advanced efficacy, and I want to get it patent. Can I do? Yes. But I have not disclosed this item, the biological item which has been used in this invention. Or I gave a false information about it. Can you oppose my application for patent? Yes. Because what is not disclosed? Geographical source of the biological material is not clearly disclosed. This is the one more ground for the opposition of patent. Last one. Indigenous. People are already using it. For example, neem products, turmeric, medicinal values of the turmeric. It cannot be patented. Clear? Understood? These are the grounds for opposition of what? Patent. Opposition of what? Can you guys write in the exam if they ask question about it? Section number 25. Section number most important section 25. Opposition to what? Patent. Opposition to. Before that, I think I've skipped this time for putting the application in what? Order for grant. There's one practical question. Can you guys solve this question? You have recently been appointed as the company secretary of the Ever Innovative Limited. Your company receives a notice from the controller of patent that the application filed by your company for the grant of patent of a new machine was deemed to have been abandoned. How you propose to deal with that matter? When it is deemed to be abandoned, if you don't put that application in order within how many months? 6 months.
Or provisional within 12 months. Provisional.
Putting the application in order within how many months? 6 months. Extension possible for how many months? 3 months. Further extension how many months? 6 months.
So even that can happen. So the provision application.
That is also possible, but this one is mainly because you have received an notice from the controller stating that your application has been abandoned. Why? Because you have not put your application in order. In that scenario, what are you supposed to do? You can make a request to whom? To extend the what? Time by providing what reasons? Sufficient reasons. What reasons? Yes or no? Can we read the answers? Read the answers, everybody. As per the provisions of Patents Act. Which year? Which year? 1970. An application for a patent is deemed to be aborted if or rules within the prescribed period. If the controller returns any document for correction or compliance, the requirement is only considered complete if the document is refiled. Within how many months? How many months? If the applicant fails to refile due to reasons beyond their control, they must do the same to whom? Control, like COVID-19, natural calamities, all those things. Next one. Further, when the controller for the compliance is about to expire, an appeal to the High Court is pending. The time for the compliance is extended until the date decided by the High Court. How many patents you own? Zero. You can get it registered. You are inventing a innovative step. What is that? He is trying to draw something on the desk without using a compass. Correct, right? So it is the inventive steps. Can you get it patented?
No, it's the prayer. It's just a mental act.
Okay. Based on the above provisions, based on the what provision? Above provisions. Even see, even method can be method of performing an act cannot be patented, but method of purifications, the process can be patented. For example, we have a patent for Kent purifier, Kent RO, water purifier. They have a patent for the purification process where generally what happens when the purification of water happens, it will eliminate all the minerals. But Kent uses a technology where you can set to what extent you want to retain the minerals and have a patent for it. They have a patent not for the product, for the what? The process. How the filter happens. Clear? Next one. Based on the above provisions, it can be based on the above provisions, it can be concluded that as a company secretary of the above innovative limited, I will see the compliance of the requirement and if appeal is pending before the High Court, advantage of that can be taken. I can see that appeal is pending, that's why I could not comply with the directions given by the control. Clear with this? Next one, opposition to the what? Patent. We have already discussed these provisions on what grounds there can be an opposition to the grant of what? Patent. What is the first one? What is the first one? Second one? Can you guys read the full point, please? So we may find some extra information over here. Please read. Applicant or the person to whom he claims wrongfully obtained the invention or any part thereof. Second one. The invention was already published in the earlier Indian patent application or in India or elsewhere. So if publication made even outside India, that is also taken into consideration. You can challenge it based on that information. Second one. Third one. Invention is already claimed in another Indian patent application. Next one. The invention was already publicly known, used in India. For this, for a process patents, if a product made by that process was imported into India before the priority date, it counts as a one knowledge job, public knowledge.
For example, if
anyone can answer this question. Like, it's not like I should only answer. If you guys also have an answer, you can answer it. Correct? And when someone asks questions, I want everyone to listen to that question and try to counter it. Huh? Correct, right? Huh? You can counter it. I will correct you guys. I will what? I will try to balance it out. Huh? Means if wherever there is correction required, I will correct it. Even last bench students can also participate. Okay, don't hesitate. Anyone can participate in my class. I appreciate the one who asks questions and doubts. Any possible questions, any discussions, always allowed. Go ahead.
there is a guy in US and
Okay. I will listen.
there is a guy in US
Hmm.
called Joseph,
Joseph.
and he filed the patent only in US, not under NC
PCT.
PCT.
अरे wait, होता है भाई. Even I make mistakes. हाँ.
So can I file IP in India under NIR? What?
That is National Intellectual Property Rights Policy. That's NIPR. So his question is, a person has filed a registration of patent only in USA. Only in what? USA. Now, an Indian person files an application in India for the same patent. In where? India. The problem here is you can make an application. The problem here is that it is already published where? Once information is already published, you will not get the patent in India.
But it's not under PCT. It's not.
But still,
It does.
once a prior knowledge is made, you cannot get a patent. But however, Joseph cannot file a case against a person who is residing in India for infringement of patent, because it is not registered in India.
So technically, we can use this technology, but we can't file an application for IP.
You can file an application, but it can be challenged because it is already published by someone else. Got it? Clear? Next one. What is the next one? What if you filed an application, Joseph filed an application on 10th before publication. Before what? Publication is not made. He filed an application on 10th in USA, normal application. An Indian person filed an application for the same inventions on 15th. Who gets the patent now? Same. See, Joseph made application on what is the date today? 29th of September. In USA, normal application, not PCT application. On 1st October, I made application in India. PCT application. Who gets the priority? Will I get a patent first of all? Why not?
You might get because it's not public yet.
It is not published. And you cannot tell me what date, priority date for registration in India. That is why you should always make what application? PCT application if you want to have a priority date. Publication is different, application is different. Only if it is already published and the information is known to the public, on that ground it can be challenged.
So will the application be valid?
Yes, it is valid in India. To avoid this, you should file an application under what? PCT. Got it? Next one. Obviousness. What is the next one? And it lacks the inventive steps. Next one, non-patentable subject matter. Section number 3 and 4. Insufficient description. Provide the required information. Convention application. The patent application in India was not filed within how many months? 12 months. How many months? Next one. The patent application fails to disclose or incorrectly state geographical source of biological material used in the what? Invention. And last one is what knowledge? Traditional knowledge. What knowledge? I want you guys to classify these 8 examples under this particular category. You guys should tell me which example is for which provision. First example, read. Is it? But what is the heading under which it will come? Traditional knowledge. What knowledge? You have to classify them under those grounds for challenge. Okay, second example. Existent application. Priority date. What date? Priority date. Next one. Obviousness. Lack of inventing steps. Non-patentable. Next one. Prior publication. What publication? Very good. Next one. Section 3. 4 is for nuclear. Next one. Insufficient information or wrong information. Next one. Non disclosure of biological origin of the ingredient. Next one. Wrongful obtainment of patent by fraud. Next one. Not informing the controller about the foreign patent application filed earlier for the what? Same invention. Means false information or insufficient information. Correct, right? Last one. Or we can also consider to the purpose of wrongfully obtaining the patent. Last one. Now you guys tell me under which point will come. Prior knowledge are used. These are the grounds on which what can be challenged. Patent application can be challenged. Yes or no? 14th one is important. 14th one, concentrate everybody, important. Simple topics. Listen. Let me describe the scenario. Before I describe the scenario, you guys tell me what you guys think out of this. Chitti. Who is Chitti? This is Chitti. Who is he? Who is the inventor? Rajinikanth. What is his name? Vasikaran. Vasikar. What's his name? Dr. Boda. Okay, Dr. Boda. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ಡಿಸ್ಕಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ಡಿಸ್ಕಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವಸೀಕರನ್ ವಿಲ್ ಇನ್ಫಾರ್ಮ್ ಅಬೌಟ್ ಇಸ್ ಇನ್ವೆನ್ಷನ್. ಈ ತರ ಅಂತ ಇನ್ವೆನ್ಷನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Then what Vasikaran, not Vasikaran, Boda will do? He will copy this information and he make an application for registration of patent. Application is pending. What is pending? It is published in the journal saying that there is an application by Dr. Boda for registration of patent. If anyone has objection, please raise an objection. Can Vasikaran raise objection? On what ground? Wrongful obtainment. Is he required to provide evidence? Yes. Who is supposed to provide evidence? Vasikaran. To who? Now controller received this application. As a controller, what you will do in this scenario? You have done the examination. Then what order you will pass as a controller?
The application is not valid and the application will be in the name of a seeker.
You can substitute the name of the applicant by whose name? Vasikaran. That is called as treating the application as the application of the opponent. In this case, who is the opponent? Vasikaran. And who is the opponent? Because it was obtained wrongfully, the controller can treat the application of Dr. Bora as an application of whom? Vasikaran. Instead of again starting the fresh procedures. Clear with this? This is a one more provisions. Clear? So let's read the provisions. What is the provisions? Let's read the case study and we will also learn the provisions along with it. What is the provision? During the if the controller finds the invention was wrongfully obtained from the opponent, the patent may be revoked. On the opponent's request, who is the opponent in our example? On the opponent's request, what controller can do? Controller may amend the patent in whose name? Opponent's name. If only part of the invention was wrongfully obtained, the controller may exclude that part from the what? Specification. If the opponent has a pending patent application or part thereof, controller may, as filed on the priority date of what? Revoked patent. What patent? He can treat that application as filed on the priority date. What date? Priority date of the revoked patent. Means he can treat Vasikaran application as the what? First application. What application? These are the rights of the controller when a patent is application is made or a person is trying to obtain a patent on a wrongful grounds. Clear? What type of question might come? Obviously the practical question. What question? Keshav, practical question, Keshav. What is the question name? What is the question? Miss Sharma. Confidentially with her colleague, Mr. Her colleague. Okay, Mr. Varma. Sharma and Varma. Nice name. Who later filed a patent application claiming the invention as his own. Can there be a post-grant opposition? Yes. There can be post-grant as well as pre-grant. What is pre-grant? Before the, we can also raise objection. Same ground, same ground. Grounds remains the same. Those 10 to 12 points. The controller found the patent is what? Invalid and revoked it on this ground. Explain how section 26 of the Patent Act apply in this situation. How to write the answer for this? Read. As per section Patent Act provides that when during the opposition proceeding, the controller finds that invention was wrongfully obtained from the opponent as per section 25 2A and revokes the patent on that ground, the controller may on the opponent's request amend the patent in whose name? Opponent's name. One more time. Read. Section 26 of the Patent Act provides that when during the opposition proceedings, controller finds that invention was wrongfully obtained and revokes the patent on that ground, controller may on the opponent's request amend the patent in the name of the opponent's name. Further, so this is one more way in which you add your points. To add extra point, what is the word you use? Further. To add one more, furthermore. To add one more, in addition. You can add the points like this. Clear? Further, if only a part of the invention was wrongfully obtained, the controller may order the amendment by excluding that part from the specification. Furthermore, If the opponent has a pending patent application for the same or part of the invention, controller may treat that application as filed on the priority date of the revoked patent of the relevant invention while proceeding with it as a fresh application otherwise. Clear? You can treat the application of the opponent as the priority date. Clear? In the given scenario, how to write the conclusion? In the given scenario, Verma wrongfully obtained Mrs. Sharma's invention and filed a patent application. Miss Sharma opposed the patent. Post controller revoked Mr. Sharma's patent on the ground. Upon Mrs. Sharma's request, Section 26 empowered the controller to amend the patent and transfer it to Mr. Sharma's since she is the true inventor. Moreover, if Sharma has already filed a patent application for the invention, controller would treat her application having the same priority date as Mr. thus preserving her seniority. This is how you are supposed to present the answers. During the opposition proceedings, if the controller finds that the patent was obtained by wrongfully, patent was what? Obtained wrongfully, at the request of the opponent, controller can replace the name of the patent holder with the name of who? Opponent. Name of who? Opponent. Possible, not possible? Possible. Clear with this? Yes or no? Then we have a simple topic. What topic? Boys and girls. What topic? What is the simple topics? Are you guys Indians? True Indians? Do you like your mother India? I've seen you guys celebrating Independence Day also. With so much of passion. Oh my. Shashank, Shashank is an Indian citizen. He has done an invention. He he believes that Japan is lucky for him. He likes Japanese things, Japanese culture, Japanese animes. I have a friend. I have a friend who likes this. Even T-shirt he orders from Japan itself. I don't. And he likes this that anime called as manga. Oh manga. You go this and say this North Indian people. Oh manga. And he's crazy about that culture. I don't know why. He likes Japanese things very much. I don't know. He's a company secretary. He's also practicing. Um, uh, Now, because Shashank likes Japanese culture very much, he want to get his patent registered in Japan, not in India, and he want to make an application in Japan. Can he make an application in Japan for registration of patent directly? Yes or no? No. You need the permission of the controller for filing an application outside India. Where? Outside India. Permission is required. What is required? Permission is required. A patent application cannot be filed outside India without the permission of controller of India. The only exception is that if you have filed a PCT application in India and after the expiry of 6 weeks, after the expiry of how many weeks? You can file a application outside India without the permission of who? Controller. Clear? Yes or no? Now read the provision. An application for registration of invention outside India by an Indian resident cannot be made for invention with respect to defense, atomic energy, controller require the prior consent. He cannot give the approval without taking the approval of whom? Government. In case of what? Defense or atomic energy, of the central government before granting the permit. Approval is not required in 2 scenarios. How many scenarios? What are they? That secrecy requirement and direct section number 35 gives the power to the central government to restrict the registration of patent. Clear with this? Question. Then I'll give a break. There are 2 questions which were asked in the previous examination. Please read. Question number 1. I want everyone to read with utmost honesty, because only when you read the question, get to know how the questions will come in the examination and how to present the answer if the question comes in the examination. Read. Wants to file a patent before filing in India. Explain whether Mr. Rao can do this under section number 39 of the Patents Act. If not, what steps must follow to file outside India? Also mention any exception to this rule. Simple question. Like, can he do so? No. Is there any procedure to be followed? Yes. Take approval of whom? Is there any situation where controller approval is not required? When same application is made in India under what? PCT, and after expiry of how many weeks? 6 weeks. ठीक है? चलो. Next one. This question. Let's just read the question. Whether he can apply outside India as provisions of the Patents Act only with the permission of whom? Controller. If it is led to the defense, in that scenario, what happens? Controller must take the approval of the central government under section number 35. Clear? Understood? We have only few concepts left. 16, 17, 18, 19, 20, and only these many concepts left in the patent. Left in the what? Patent. Once we finish this, we will complete. We have a new quiz today with around 26 questions with the lead vote. We'll finish that for the revision purpose. Once that is done, we'll start with the trademark. So we are done with provisions, and we also discussed all the previous year questions. Most of the previous year questions for this particular chapter. Okay? Before I give you the break, your breakfast break, I'll ask you questions to you guys, and you should answer. Okay? Quick answers. Within how many months a complete specification to be filed? Within how many months you should make a request for publication of? Earlier publication can be made within 15 months. And that is for withdrawal of. That is what? 15 months is for withdrawal. Within how many months the controller should publish the application if request is made? 1. Within how many months there should be a request for examination? Data application. Within how many months you should make an application outside India if the application is made under PCT? 12 months. Time limit for making the application. PCT application. How many months? 12 months. Can the patent controller of patent substitute the name of the applicant? In how many scenarios? What are the 3 scenarios? Assignment or agreement, operation of law, that is death of the original applicant, or in case of joint applicants. Substitution of what? Applicant. Can there be a direction by the controller to include a reference in the complete specification to the existing patent?
Yes.
When? When the inventions mentioned in the applicant cannot be worked without infringement of the existing patent. Can it be deleted?
Yes.
When? What are those four scenarios? When it is revoked, when it is ceased to be in existence, controller's orders for it, or court orders.
Or it is invalid.
Challenge. What is it? Some other thing. As invalid. Done. One more question. A discovery of a thing, patentable, not patentable?
The section.
Correct. If there is a prior publication of information, can it be challenged? Under section number 25. What is PCT? What is the advantage of it?
You get the prior
That provides the platform or mechanism for filing an international filing system, where a person can establish a priority date for registration of patent. PCT comes under which organization? What is WIPO? Intellectual property. Or what is TRIPS? Intellectual property. What is NIPR? Policies. If I invent something, if Keshav invents something, how to do this drawing without using compass, what he will get? Patent, copyright, trademark. Invention. Patent. What if he has done a drawing on the table? He has drawn a picture. What, right? What if he has drawn a picture of a person? Can we get it patented without the consent of that person?
No.
Why not?
personal rights.
He has drawn a picture. Who gets the patent right? First of all, can you draw a picture of someone without the consent of other person? Let's say you have taken a photo. You take a photo of someone. Can you copyright that photo?
No, without the consent.
Okay. Let's say a monkey takes a selfie. A unique selfie. Who gets the patent for it?
So the caretaker of the
That is the only possibility, but this is actually an interesting case where a gorilla has taken a selfie and they wanted to claim a copyright for that. But accidentally the gorilla took a selfie, like, and they filed a application for copyright. And for copyright violations, you can see this movie called Dhanush movie is there, right? In Tamil, Mayakam Enna. That movie, in that he copies that the assistant copies the artwork. Can voice it. When you guys find free time. Anyway, so we'll take a break now. Post break, we'll finish this chapter. and then we'll solve the MCQs. Then we'll start with the trademark. One more important chapter. Done. You guys should be back by. Hey, not 11. ठीक है. Exact 11. Not 11, 11. Exact 11. Oh. No, 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 no. Mm-hmm. When you guys are in the class, it is always a good vibe. You don't need a time to have a good vibe. You guys are such a good vibe. Ask Keshav. Huh?